Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Now this evening I'm looking at a book which has come to us from Jordan Publishing. It's part of the Jordan company Family Law imprint that we're looking at today. The title of the book is The International Survey of Family Law for 2015. It's been published on behalf of the International Society of Family Law, the general editor being Bill Atkin. The book's also available as an e-book, and I think anybody who's involved in the family law jurisdiction will find this book of great interest. It is an international book, but there again a lot of cases we have today are in fact of an international character. My wife Elizabeth and I have looked at this book and the review which we've put on the web, and then we're sending it to the journals. It's really covering the latest developments. So the title of our review is The Latest Family Law Developments Worldwide, including Canada's Zero Tolerance Act. More about that in a few minutes. Let's just have a quick look at the book. It's a hardback. There we go. You can see the front, the spine, and then the back. There we go. It's a hardback. Nice sturdy book. Runs to something like just under 400 pages. There is no index at the back. As you can see, it finishes with some conclusions in the final chapter. There are footnotes, which you can see at the bottom there, and you do have page numbering. Let's look at the front. There's the actual front page of the book, and then after that you've got the content section. You've got the members of the International Society, and then an overview of what the society is. Then you've got the various countries which are covered, and you can see we start with Australia, and then it runs all the way through, covering a very large number of countries all the way through, and it's done alphabetically, so you end up right at the end with Zanzibar right at the end. Then after that you have the members, as I say, of the society, and then you have after that you have an overview of what the society does, the history of it and what it's done. Then there's a preface, and it says here, "I'm writing this the day after the news broke that the US Supreme Court has decided in favour of gay marriage." And again, that's the start of it. We see such a substantial change. It's dated June 2015 for the preface, so you've got some idea of where it is. And then you go straight into the issues in Australia, and then it runs all the way through. There's a resume at the start to set the scene, and as I say, you have, instead of paragraph numbering, you do actually have the main numbering of the actual subheadings, and of course you've got a lot of footnotes all the way through. But it is actually structured on the basis of the individual countries which it covers. Not all countries, but the vast bulk of the ones that we are actually interested in. So let me just say a few words about the book itself. If you're a family lawyer, you probably know about the International Society of Family Law, but don't worry if you don't, because now you do. Be it known that this organisation, which was launched at the University of Birmingham in 1973, publishes, among other things, this important and up-to-the-minute annual review of significant and noteworthy developments in family law across the world. Been published by the Family Law imprint of Jordan's, and this is now the 2015 edition of the International Survey of Family Law, and has been compiled under the editorship of Professor Bill Atkin, who comes from the Faculty of Law at Victoria University of Wellington in New Zealand. And he says, "I'm writing this the day after the news broke that the US Supreme Court has decided in favour of gay marriage, causing a mixture of jubilation and consternation," which I mentioned. That's the starting off point for 2015. He goes on to say the US illustrates the vital role of the courts, accompanied by an interplay between the Constitution and the various federal and state legislation. So you see where he's coming from. He then contrasts New Zealand's positive vote with a negative vote in Australia on the same issue, whilst also reminding us that Ireland, a staunchly Catholic country, also voted almost 2-1 in favour of marriage equality. Atkin comments that for the most part these developments in the West are not replicated anywhere else, which is an important point because there is clearly, in terms of jurisprudence and practically, a big divide which is building up. Interesting point to note, and we'll see what happens in the course of time. It is, of course, based partly on religion and political and cultural views. Predictably, a substantial percentage of the contributions from the 22 areas, from Australia to Zanzibar, which are covered, discuss in this volume, as I say, on a country-by-country basis, a range of issues relating to marriage in, for example, Europe, France, Puerto Rico, Scotland and India. And international developments in other areas of family law are, of course, also covered. But you've got a fairly broad range here by which you can gauge some views of what is actually emerging as current views at the moment across the globe. Particularly interesting, we thought, and certainly timely, is a piece of legislation now emerging from Canada, referred to by Martha Bailey in the chapter on setting boundaries as, quote, an effort to demarcate civilised marriage from barbaric forms of marriage. This is fiercely named Zero Tolerance for Barbaric Cultural Practice Acts. That's the Zero Tolerance Act. And it was passed in March 2015 by Canada's Senate and subsequently referred to Canada's House of Commons. And the Act is designed primarily to render forced marriages and other barbaric cultural practices illegal. And that's, of course, FGM that we are also referring to here. Expanded on the intent and impact of the Act, the Canadian government has declared officially, and we quote, that Canada's openness and generosity does not extend to early and forced marriage, polygamy and other types of barbaric cultural practices. Canada will not tolerate any type of violence against women or girls, including spousal abuse, violence in the name of so-called honour, or other mostly gender-based violence. Those found guilty of these crimes are severely punished under Canada's criminal laws. Well, we'd like to think that was the case here, but it isn't, of course, because of the total number of prosecutions so far, which are pitifully small. The statement further cites Canada's commitment to standing up for victims of violence and abuse and to send a strong message to those in Canada and those wishing to come to Canada that such practices will not be tolerated on Canadian soil. And we will go on to highlight this particular point with this survey, that it is more than clear that this is that in this ethically diverse and famously tolerant country, which Canada is, as I know it, and my wife knows it, and if you go to any of the big cities you'll know how diverse it is, the tolerance level of mainly mild-mannered Canadians has hit zero on this issue, and a number of other odious, repellent issues, as they've not exactly minced words in the wording of this Act, which I suggest is possibly one of the leading international aspects of this particular title. It's also proposed that prohibitions on polygamy apply to temporary as well as permanent residents of Canada. Now, I just wonder, on the basis of this precedent in Canada, whether that will, in the longer term, have notice taken of it elsewhere. Let me conclude by saying that Martha Bailey's essays, as well as the other scholarly contributions in this carefully footnoted volume, make it a fascinating and diverting read. It's also a mine of up-to-date information on developments in family law worldwide, and it will certainly broaden the perspective of both family and international lawyers everywhere, and should be regarded as an essential purchase for the well-stocked family law library. The publication date is cited at June 2015. It's the book again, just a quick look at it. There we are, spine and then the back. If I just open it in the middle, we've got here, this is actually Fiji and Samoa that we're looking at. So we do have a very wide range of the different countries covered. I'll just read them out. Australia, Canada, England and Wales. Then you've got European law itself, and that is a much wider area covering Article 8 of the Convention on Human Rights. Then you've got Fiji and Samoa, France, India, Ireland, Japan, Korea, Mauritius, New Zealand, Poland, Puerto Rico, Scotland, Serbia, Slovenia, South Africa, Switzerland, the United States and Zanzibar. So you've got a very interesting range, and you can see just looking at it, for instance, this is Korea, and you see each chapter actually finishes with a useful conclusion, and then you go on to the next one. This is Mauritius. protection orders under the Mauritian Protection from Violence Act. And I think the point that you get out of this is that you can see that, as I've said many times before in the countries I've been to, that when you take away the tag of the country concerned and then you see the people as they are, the issues they face are common issues that we have as humanity, and we really have to get it right. The question then is, who is going to take the lead to try and set down precedents by which we can behave perhaps a little bit better, certainly when it comes to gender-based issues. Thank you very much to all concerned. It's a very interesting read, and I'm sure many practitioners will find it of great help with their practice. Bye-bye.